Pessoal, antes de começarmos aqui o nosso seminário, gostaria de dar um recado para os alunos da pós-graduação para assinarem a lista de presença, para quem não esteve agora de manhã, e também para assinarem com a Aline a segunda lista para certificar que vocês estavam aqui, certo? Now, welcome back everyone for our gig economy seminar, the afternoon sessions. We are going to have a panel now for the platform work and economy. For this session, we invite to act as president the PhD and Master in Labor and Social Security Law by Universidade de São Paulo, the Labor Public Prosecutor, Your Excellency, Mr. Renan Bernard Calil. Please.
Well, thank you very much. Good afternoon to everyone. To start this panel, I want to, first of all, express my gratitude to Professor Adriana Calvo for extending the invitation to moderate this panel about this such important topic on platform work and economy. And I also want to extend my congratulations to Professor Antonio Rodrigues de Freitas, Júnior, for coordinating this seminar with such distinguished experts to delve into this important topic. Here in Brazil, we have this debate surrounding the regulation of platform work and gig economy for a couple of years, especially since the July 2020 with the break dos apps in the major cities in Brazil. And the most recent endeavor to address this issue was the submission of a bill by the federal administration, the President Lula sent to Congress, a bill to proposing new regulations for drivers for ride-hailing apps such as Uber. And the bill is the outcome of a tripartite working group that was a clear victory for the companies because the bill is express the idea of the need to create an intermediate category of workers to regulate this kind of work. And this is we have a debate surrounding this topic because in place of paying the workers the basic employment rights, the companies want to legalize what they already do here in Brazil and elsewhere in the world, paying workers by piece and limiting social protections. We saw similar movement in the United States. The California approved the Proposition 22 in 2021, when the most important platform companies such as Uber, Lyft, and Instacart spend $223 million to pass a bill that created a similar worker category to regulate this kind of work. And despite the promises that the workers would receive minimum wage and a healthcare stipend, what at least empirical evidence shows is that workers are receiving $6.8 per hour, which is roughly 1/3 of the Californian minimum wage. And almost no one is receiving the healthcare stipend. So this is something we should look at if you want to follow the Californian law. And this is important to try to understand because the whole world is looking to this kind of topic. And recently, the European countries, they reach a provisional agreement to reach a directive for European countries that they are creating a legal presumption for employment rights when certain criteria are met. And the main idea is that member states will establish a legal presumption of employment according to national law and collective bargaining. And it's up to platforms to show that actually the work dynamics does not match with the employment rights. So this is something we should look at as well. And just to finish this introduction, I think we also should look at what Portugal has done last year. They already enact an amendment to their labor code and introduced the Article 12A, creating this legal presumption and establishing a set of criteria. When they are met, workers are considered employees. And in the other way around, here in Brazil, the bill that the federal administration sent to Congress, we had a similar set of criteria that the Portugal established in the Article 12A, but when they are met, according to the bill sent to Congress, workers are not considered employees. So we have this situation, and well, here we are debating and standing in the crossroads of the future of work and trying to understand the better solutions to regulate this platform work. So without further ado, I want to introduce Professor Marcelo Manzano. Professor Marcelo Manzano is a professor at the Unicamp Institute of Economics and researcher at the Center for Union Studies in Labor Economics, CESIT, and he will speak about digital platforms between finance and work. So Professor Manzano, thank you very much for joining us here today, and I will give you the floor.
Hello. Let's see. Well, thank you, first of all, Adriana, to invite me to this meeting. Professor Freitas, and it's a pleasure to be here. Calil, Dr. Calil, we met in virtual spaces before. Professor Wilson, it's a pleasure to be here. Sorry, my English is a bit out of shape or rusty, but I try to do the best here. I prepare a PowerPoint. I will follow the PowerPoint to show you what I prepared. When I talked with Adriana, she asked me to I'm not from the labor relations studies, but I studied the platform, the digital platform, thinking in the dimension, the connections of the platforms with the economic, with the environment, economic environment where they are playing. Yeah. Then Adriana asked me to introduce the discussion about the platform, but from a point of view of the economic environment. That is my effort here. Well, let's see how this works. No, not here. Yeah, we have our issues with the platform here also. Okay. Yeah, let's go. Well, onde é que tá mudando aqui? Será? Não tá? Eu acho que... here is. Well, what's my hypothesis here? about this question. Peraí. Como é que eu mexo isso aqui? Luiz sabe. Tô tentando. Tá bom, tá bom. Beleza. What's my hypothesis here? Although the new metabolism of capitalism may appear as a result of 4.0 technology, digital technology, or the process of deregulation of the labor markets, the digital platforms, in my hypothesis, and their disruptive ways on managing the working force are a phenomenon that, aided by the technological revolution, respond to the discipline imposed by the sphere of the financial accumulation. That's it, in my point of view, the main aspect that move the platforms to be what they are. Yeah. In this sense, first of all, platforms are an offshoot of growing importance of managing old wealth. That means property rights that use them to move away from the inconvenience of the producing new wealth. Yeah. Then the platforms help the financial capital to move from the real accumulation environment, move to the financial accumulation, where they manage property rights, old wealth, and not create new wealth. That's my point here, my hypothesis, my central hypothesis. What's the context? The general context, we are observing a profound transformation in the metabolic system of capitalism, whose repercussions are highlighted by the following aspects. First, the absolute dominance of the financial capital, and not the productive capital like 50 years ago, when the Fordism was the main kind of capital accumulations. Another aspect, there are new strategies of accumulations. Yeah, we will talk this after. There is a dissemination of the digital technologies. Of course, we are seeing this. We have our smartphones with a lot of gadgets, etc. There is new statute for the business organization. The business organizations are being transformed very in profound way. Yeah, and there is finally a dissolution of the employment relationships. Yeah, this is the main aspects of this context. Some questions. How did we get here? How did this metamorphosis in capitalism happen? How does capitalism operate under the control of finance? Well, it's important to remember the commercial and financial liberalization and that has advanced since the 80s, when economists say when happened the end of the Bretton Woods era. This leads to a radical transformation in our system, in the capitalism system. First of all, an unprecedented widespread of uncertainty and volatility will happen, will be seen. It opens a space for speculative gains and financial valuation. Also establish the preference for liquidity as a norm, not just the preference for liquidity in the crisis that was the perspective that John Maynard Keynes are discussing in his books. Also, another aspect in this context we see the stimulates of the creation of the sophisticated and liquid financial instruments that in economy we call the securitization of the system. There is a space where the agents could buy or sell their assets anytime, any hour, in any place. This is important to understand how the platforms in the end will get money from this environment. Another aspect, there is a radicalization of intercapitalist competition. The competition between the companies is much, much higher, aggressive nowadays than 30, 40 years ago. Corporations turn to very short-term operations. The corporation look to get valuation tomorrow, in a week, but not. They don't look more for 5 years, 10 years, 20 years. This doesn't matter for them. This is important also to understand how, for example, the platform companies like Uber, like in Brazil, iFood, like Nubank in Brazil is the most important bank in terms of value. All these companies, big platforms, they don't realize gains. They have year after year they operate with losses. Why this is possible? Because they don't look for the future. They have the short time only as the main issue in terms of valuation. Capital moves towards the management of old wealth, valuation of property rights, to the treatment of strategies of generation new wealth, what we call the productive accumulation. We go into investor-driven mode. That means that who gives the design of our capitalism, of our economics nowadays, are the ones, the interests of the investors in our society. Yeah, they shape our lives more than before. In this context, digital technologies emerge as a powerful instrument for the radicalization of financial accumulation strategies, promoting a profound transformation in the status of companies and labor dynamics. From the process of economic digitalization, we have advanced to platformizations, because if we look in the text, the papers, a lot of people was talking about digitalization since the end of the 90s, the beginning of the 2000s. But in the last 10 years, we moved to the platformization that have a lot of reasons to be linked with the smartphones, when the people could bring in her pocket a lot of connection with the economic life, with the social life, etc. Then a mode of capitalism accumulation that overlaps the old economy, establishing a hierarchy between companies and imposing a draconian and unprecedented standard of value extraction. And here is where I see the place of this platform, digital platform that commands works, labor. the platform companies establish themselves as a buffer, in my view, something like a cordão sanitário em português, falamos, a buffer between financial funds, the world of the big money, hedge funds, private equities, venture capital, etc., and the old economy, the restaurants, the factory of motors, etc., the mobile, etc. My point here is the platform, the digital platform, the function as a buffer between these two spheres to protect the first, the financial capital, the financial sphere, to the old economic realization, production. Yeah, this buffer separates capital in its most abstract and liquid form from the liabilities and risks that are traditionally associated with the capital accumulation process. Which liabilities and risks? The fixed capital is very bad for a company to have money fixed in a build like this for 10 years, for 20 years. They want to get liquidity to find the most important alternatives to maximize their earnings. Then fixed capital, they don't like this. This is bad for the financial accumulation. Then they transfer this by using the platforms. The labor obligations also, of course. The regulatory risks that are involved in any kind of production accumulations, civil and environment liabilities, government arbitrations, that means risks for the private companies, etc. Well, let's see then more how I understand this two spheres, one determining what happened in the other. Then more than before, this is not new in capitalism. This is from the beginning, but now this kind of relation is more explicit and is more higher than ever. More than before, the accumulation process takes place in two instances. In the first instance, or now in the bottom, are the real accumulation, the material base, the sphere of production. And the top sphere are the fictitious accumulation of capital. That is a capital that realize the possibility to earn by speculative strategies. Note, there is no quantitative correspondence between the two spheres. There is no correspondence between the two spheres. How I said, Airbnb could be in systematic losses in his operations, but the company, the assets of the company could appreciate a lot. Yeah, could be in a process of valuation, but very dynamic. And there is no correspondence, a correlation between these two spheres. There is, it's true, an existential link between these two spheres. For fictitious accumulation to exist, to happen, it is enough that in the sphere of the real accumulation, the production, they could say that they could view that is a possibility of credible accumulation in the future. Only that is important. The rest is secondary. Yeah. Here I try to make a picture about what I'm talking about this situation where the platform is are a buffer, yeah? Here is a picture of the first sphere, the real accumulation. We have the investment funds, the big money, the abstract wealth. They send, they buy, they invest in the platforms, their money, and the platforms transfer the risks, the costs for the sphere of production, transfer the cost for the workers, but also transfer the costs for the small business, for the restaurants, for the little service, etc. Yeah, companies that are working in the real world. And they extract money from this operation. But the real money doesn't come from here. We know there is other strategies that capture money in this system, but the picture that they sell in the market is that. And here is the second sphere of accumulation. They transform that design, that architecture design, in a paper, in a financial paper. And they send this financial paper in the markets, in the financial markets, for the equity, the private equity funds, for the hedge funds, for the venture capital, in the financial market, etc. This business design applied to a certain type of activity becomes a financial asset whose value is determined by an expectation of extraordinary gains in the future, not today. They lose today, but they promise gains in the future. And what is the logic that governs the ecosystem of the digital platform in this model? Yeah. From the beginning, since the beginning, if we talk with any one of these guys that are involved in the startups that create digital platform, they say that since the beginning, the platform startups set themselves to attract the interest of financial funds. This is their initial aim, objective, yeah, targets. They want to send the startup for a big fund, big money, some big tech also. The best way to do this is to build an economic valuation architecture that brings future yield expectation to present value. This imposes bold combinations of value extraction and risk mitigation promise. There where the workers will be involved. And main valuation strategies adopted by the digital platform, we know, but it's important to point here to note, are those. First, the datification or datification, the capture, interpret, and sell records and behavior information from the customers and from the citizens. Yeah, what we do in our lives have been captured by the platforms to transform in goods and sell for other companies. Another strategy that I think is important, especially for you that are thinking about the point of view of the law, the regulatory arbitration. Yeah, a typical once-for-all gain that platform could do related to change in company's status from a regulate to a non-regulate business model. The company that are in the beginning of this movement, made this movement in the first time, they win a lot of money. Dumping is another strategy of of valuation of these platforms. Dumping is they operate a long periods below cost with frequent losses, like I mentioned before. Another one, conquest of monopolies by virtual enclosures. Yeah, virtual enclosures. You can go away from, if you want to buy a book, you need to go to Amazon. You don't have another option. The platform that could achieve this situation, they have power and a possibility to evaluate their assets. That is stupendous. It's a lot of money just if you can design this possibility. Another one, they operate with low dependence of fixed capital. I said this before, and with a few liabilities as possible. And also, finally, they promise, they look for a kind of labor managing that means a high labor exploitation, mainly by the non-recognition of employment relationships, like the discussion in Brazil nowadays about the new proposal for to regulate the drivers of platform in Brazil. Well, the growing participation of digital platforms has drawn attention to their disruptive effects on the world of labor. Of course, we know that, but it's important to highlight. Among the main ones, we can highlight high fragmentation of work routines, the trade-off from jobs to tasks packages, growth of informality and lack of social protection, transfer of economic risks from the companies to the workers. The emblematic, the most clear example is the Uber driver that has to pay his own car capital and not the Uber, or another, or Airbnb is the same, and other ones we can see that. The reduction in the amount of paper hour of work, expansion and intensification of working hours. I think Professor Wilson will show some example of that after, yeah, in the case of Brazil. Well, and how big is the work under the control of platform in Brazil? Just to give some small numbers or quick numbers after Professor Wilson will show in more details. The analysis of internet traffic data indicates that since the beginning of the pandemic in Brazil, labor activities has increased under the command of digital platforms. In 2022, there were approximately 2 million people working under the control of digital platform in Brazil. That is about 2% of the labor force of the country. And in this group, 90% of these workers were in the transport sector. In Brazil, the digital platform is mostly a case of transport, driving for people or making delivery of goods and service. Yeah. Just a quick comparison here. If we compare the labor markets in specific sector of transfer of passenger transports, the drivers, comparing the old model with the platform model, we see some important difference here. This is numbers from 22. In the platform workers, they usually work 52 hours per week. The regular workers, the traditional drivers, taxi drivers. They work in media, in average, 41%, 41 hours per week. The wage per hour platform received $2 per hour in Brazil in 2022. The traditional, the taxi driver, $2.4 per hour. The age also is very different. The platform workers are usually, in average, more younger, 35.3 years, and the taxi drivers 45 years, 10 years older. One thing that is important to highlight here is a difference, a substantive difference. The percentage of women in the platform workers, there is a huge more importance of women driving cars. 21%. In the other case was just 2.3. And another important, huge difference is the higher education. In the platform workers, we see mostly near half of them have some years in higher education. In the case of the taxi drivers, the old drivers, only 5% is much, very important, this difference, I think. But to think about all this new complex situation and how to manage, how to fight against this situation, what we can do. I highlight here some suggestions. Yeah, acting directly on the deeper causes of this problem. First, in my point of view, the most important way to regulate this world of the digital platform of work is to regulate and taxing the financial funds, not only the platforms company, but the financial funds. The problem is in their dynamics, their wants, their pressure under the companies. Yeah, like President Franklin Delano Roosevelt did in 33 with the Glass-Steagall Act, when Roosevelt blocked the transfer of money between different segments, different parts of the financial markets. And this worked very well until Bill Clinton in 1997 finished the Glass-Steagall Act, and all the speculation start again. I think it's important to fight against the platform, first of all, in this sphere, in this kind of business, the big finance. But not only. I think it's important also to prohibiting the private appropriation of data produced by social interaction. Like we can see now how Musk tried to interfere in the public and the political environment in Brazil, but not only. I think this is an important thing that we must try to regulate this data appropriation, the datification and the money that they get from this new space of accumulation. Another thing that I think it's possible and we must to try is to create public platforms. Yeah, public platforms. It's easy. It's not the government can do that by law. Yeah, and there is not a secret, a technological secret. It's possible. It's not difficult. Another thing, I think it's good, but it's not easy also, because the big platforms have the monopoly of the situation, but I think we need to support cooperatives, platform in cooperativism environment or solution. And also, of course, new forms of labor regulation, like in Spain, they are trying, in California, but that's not my field. I know this is the issue that you are discussing here in other sessions. But I think in some small letters here, this is some recommendations that I see that is important to try to act in front of this situation. Yeah. Yeah, thank you. Here some bibliography, and I think it's all. Thank you.
Thank you very much, Professor Marcelo. I think we are facing a couple of these challenges here in Brazil with the Musk tweets. Now the debates on how to regulate social media here in Brazil are returning to the public opinion newspapers, and everyone's debating this right now. And also also regarding the how to regulate labor in the platforms, we have this debate beyond how the law should classify workers, but also alternatives such as platform cooperatives and such as things like this. So thank you very much. And now we will have Wilson Aparecido de Costa de Amorim, who is professor at FEA-USP here in São Paulo and director of Human Resource Department of USP. Professor Wilson will talk about algorithmic management of digital platforms. Professor Wilson, I will give you the floor.
Thank you. But I will... What I would... Nós vamos entrar com qual aqui? I like that. Okay, guys. Hello, good afternoon. I'd like to say thanks for the invitation did by Professor Freitas and Adriana and Professor Tippett. I'm really will say something about labor market, the entire labor market, and about the self-employed workers insertion, and now in Brazilian labor market by now. And I'd like to show some facts, some events on the labor market, in order to try to understand who they are, what about the people that are working under this gig economy condition. This is my point by now. Okay. And I will divide my presentation in 5 parts, and I will say something about definitions, because I will speak about labor market statistics. And just for the beginning, it's important to say it's very hard to identify what's really happening, what really happens with people who are working under this gig economy condition. This is a technical problem about all of kind of service that try to catch these specific conditions of these workers. I will say something about the Brazilian labor market in general and self-employed workers in order to try to get a dimension of that in Brazilian condition. And inside of this entire group of self-employed workers, I will speak about the transport and logistics subsector workers and the final remarks. I will show some numbers. I will show some observations from the PNAD Continua. Is a continuous national household sample survey from IBGE. Is a national survey with a national coverage more than 3,500 cities and more than 200,000 households. And we may access these results every month or every quarterly or in annual period. And from the beginning, it's important to define what about which is employee for PNAD. Employee is a person who works paid by wage, salary payment. And in Brazil, of course, it's possible to be employee in a formal or informal hiring. It's very important to say that in Brazil, because it's not so common in Europe or in other countries, but it's possible to have an informal link with companies. And it's a very big problem to say that in a law school, but informal work in Brazil, it's not so very, very legal work because it's very useful, as we may see normally every day. A self-employed worker is a person who is using his or her own enterprise, formal or informal. Of course, we are in Brazil. We have formal and informal possibilities of companies or workers. And then we will I would like to point out more facts about self-employed worker. Okay, we have the employer. It's not employer have a company and have employees. And of course, again, it's possible to be employer in Brazil in a formal and an informal way also. And in order to understand more about self-employed worker, we may define a company formality in Brazil when the company has a CNPJ, a National Register of Legal Entities. It's a unique number at the Federal Revenue Service. And this is important to define who is formal and who is informal when someone works as a formal or informal worker or self-employed worker. And let's talk about the labor market in Brazil. We have some structural characteristics. Since we formed our labor market after the end of the slavery, it's our common form. We have a big heterogeneity, because we have a very diverse conditions of labor and hiring in Brazil. When we compare regions, when we compare different sectors, when we compare even inside that same sector, there is a very big diverse conditions of hiring and income and kind of quality of the hiring. And this is Brazil, right? Heterogeneity condition on labor market. And also connected with this first structural characteristics, we have inequality. We had a lot of people with very low income and a small part of the labor market with high income. We have this because we have a very diverse conditions around the country, around our several regions, because we have several different conditions inside of the economic sector also. And high informality, as we may see, as I said before. And mixed with these structural characteristics, when we observe what's happened from the last years or last 10 years, I will deal with this period, the last 10, the period beginning from 2011 to 2022, we have, of course, the technological transition. Professor Marcelo explained what's happened in the bigger picture, and with a digitalization. And these things changed a lot, every kind of labor process, in every kind of sectors, economic sectors. We have, of course, a very strong change in the labor laws towards flexibilization, and with the labor reform in November of 2017, and also in a very strong change, the law about outsourcing launched on March of 2017, and pandemic. Of course, pandemic. This is our bigger collective experience about life, about studies, and about labor, of course. Many things are pressured ahead by the pandemic, and labor process, of course, and the labor hiring also. And we experienced many changes at the labor market during this period. Okay, we are living the consequences of these three big changes in Brazil. They are mixed, and they are trying to observe, trying to understand what's happening, really happening as a trend during this period. This is what I'm trying to understand, observing just the self-employed workers group. And I promise this is my first and unique table with numbers here, okay? But it's important to see that we have almost 100 million people working in Brazil. This is the first line. And we may observe that this labor market, this group of people occupied, has a growth of 8.1% during our period. But look what's happening with the self-employed workers group. This group increases more than the rest of the labor market. And we have on the third line, the group of people who organized in a company, in an individual company, in a formal way. This group had increased more than 100% during this period. There are a lot of people organizing his own company, his own individual company during this period. And the fourth line, at the fourth line, it's possible to observe that we have a very big amount of people working as a self-employed worker, but in an informal way, without CNPJ, without the formal recognition at the Federal Revenue Service. And from this table, I will speak more on the next slides. And so it's very important to observe that the employee participation decreased during this period, and decreased inside at the private sector. And we observed 3% of the participation falling during this period. But it's possible to see that almost in another direction, we have the increased participation of the self-employer worker. And then this group increased from 22% to 26%. And this is a very strong trend. It's a structural trend in Brazil. And let's think about what will you do with these guys? What will you do with these guys when they have formal companies, formal individual companies? What do they have? No formal or informal individual companies. Inside of this group of workers, the bigger part is composed by commerce and service workers. And we have 74% of informality in this group of self-employed workers sector. But it's important to observe, even with a very high level of information among this group, self-employed workers, we have a strong trend toward a formality. We have a small group, but this small group is growing during the last years. This is what we may observe at the labor market in Brazil. We may say more things about these groups. The first thing is traditional sectors who operate normally in informal way, now they are becoming formal workers under a condition of self-employed workers at construction, housing, restaurants, food, and these groups of workers normally earns or normally has low income. And on the other side, on the top of the labor market, it's possible to observe a new group of self-employed workers growing also. People who are working at IT sector, education sector, and health and care sector. And these guys have higher income in comparison with the group of traditional self-employed workers. This is what they say about this. Okay, we have two groups on the bottom, traditional workers and traditional sectors as self-employed workers, and we have on the top a new group, or we may observe a forming new group with high qualified workers with more income than in comparison with the other. It's possible to observe that this group of self-employed workers are following the general trend of the Brazilian labor market with elevation of educational level. This is what's happening with our population. This is what's happening with our occupied group at the labor market, and also at this group of self-employed workers. And another point, I would like to point out that the spouse participation increased among of the self-employed workers group. And it's interesting to say that normally a second person at household decided to get a job, but to get a job as a self-employed worker. And what we're thinking about is these people are trying or aiming to complement the family income. It's a kind of strategy, and this is a way to include more people on the edge of the labor market. And I guess, yes, in both cases. And when we observe at another sector linked with this platform services and transports and logistics subsector is the case, what we may say, the self-employed workers at transports and logistics sectors increase as the rest of the labor market. They are following the trend in some sense. And I have another number here, and drivers at platform workers, trucks, cars, motorcycles, and bikes. I have a number around 1.5 million workers, and this is almost 70% of this subsector workers. And I will stress again, it's very difficult to really identify the size of these groups, because there is no what I may say, the traditional survey about labor markets normally was prepared to take care about European labor markets with low informality or no informality, with a traditional wage and salaried workers to identify at the occupation. But it's not the case what we are living in Brazil or in other countries. We have different things happens at the labor market. Different conditions on hiring, different employment or hiring in relationships, and it's very difficult to really calculate who and when and how much they are. This is a point, it's an important point. And look, we are talking about almost more than a quarter of the occupied people, and it's very strong to easy and very strong to get a precise photograph from these people. And so let's talk about what's happening about the working hours from these guys. We observe that they are higher than other self-employed workers sectors, but people who is working at the transports and the logistics subsector, but they are reducing their average working hours during this period. And I stressed this observation because when we observe what's happening about working hours, we are discussing about how much hours they are supplying on the labor market, how many hours they are able to work during this labor period. And what we are observing, they are working less. They have very high working hours, but they are working less than from the beginning of our period. And when we observe at in another aspect, the real average income, we observe that they are reducing during the period. Look, we will combine this. There are more people trying to work as self-employed workers on transport. They are offering the labor as a job, but they have a high working hours average, but this working hours average is reducing. They are earning less. They are earning less. And I tried a possible narrative from their working hours and the real income. Okay, the first conclusion is they are a flexible jobs. There is no doubt. They are flexible jobs. The increased supply of labor force at this group results in a fall of their average income and also average working hours. And this is more supply of workers under the platform action, under the platform management, under the platform politics, in some sense, results in lower average real income. They really share the costs with the workers. They really push it, the costs and risks in the workers' direction. And what we may observe at the Brazilian labor market from these last years, we are trying to manage in Brazil, in our country, we are trying to manage the new occupational structural trends. Okay, We are following the trend, reduction the labor costs. And the second, we are discussing about protection law, and when there is no doubt about this, it's easier than on the past to open an individual company. Now it's easier than the past to have our own individual company. In Brazil, we call these companies microempresas individuais, or as acronym MACE. We are trying to approve and adopt specific labor and tax laws for platform and jobs. And of course, we are dealing with the need to have more larger public social politics, because people who could work sometimes, and sometimes it's not possible to get a job at the labor market, and it's necessary social politics, of course, and a public social politics dialogue with a labor specific policies in this sense. And so, in the final remarks, I may say, and this self-employed worker sector, and also the transport and logistics subsector, kept and reproduced the same Brazilian labor market structural characteristics. Okay, now it's easier to have our own company, our individual company to get a job, but we have the same characteristics that we have before the law. Before the law, we have it. We are in heterogeneity, we have inequality, and also have informality high but decreasing. This is important to say. I don't know when the informality from the sector will disappear. It's impossible to say, because just a quarter of the self-employed workers are in formality by now. How many years we need to catch these people in a formal way, the entire group? And so this is what I would like to say. Thank you.
Thank you very much, Professor Wilson, for your talk. And I don't know if you will open to questions right now.
So I have personally a question to Professor Wilson. Let me use the microphone, otherwise the records. The question I have, and probably I'm not wrong. I think we have already debated about it. The business of platform seems to me that I'm not economist at all. I don't know economics, but seems to me that it's a very tend to be a monopolistic market, in the sense that as soon as a platform is established in one city or in one region, it's very difficult to see to preview some new entrants in this business. Would that be right? Would it be correct, my impression? I'd like to hear about it from you. From both of you, if you want to.
In English, yeah. Yeah. No, but it's okay. It's a suffer for me. But okay. Yeah, I think, yes, the monopoly is an important aim for the platform companies. They look for that since the beginning. And this is an existential question for them. If they don't organize almost an oligopoly. They don't survive. Yeah, and who made the monopoly first will win all. Yeah, this is the game, and they use a lot of strategies to fix it. To organize this monopoly. Yeah, operating by dumping under having these losers, because then the conquerors can't invade the space because they don't have money enough to survive with losers. Yeah, it is very common. I think it's a important aspect of this environment, of these strategies. And one time they consolidate this monopoly, it's very hard to break, because what I saying before, if I want to buy a book, I go to Amazon. I don't know where more I can find a book. Or if I want to take a taxi, I go to the most important one. I tried before, for example, to take a driver in a cooperative that work here in São Paulo with 17 drivers. I tried. I am a friend from. I talk with one of them. Oh, great! We need to fight in this way. And then I tried to wait this taxi, and it's impossible because he was in the other side of the city. I can't use. I didn't have time to do that. Then I think the monopoly is fundamental pillar of this new kind of business model. Yeah.
Pardon about economics, but also monopsony. Because there is no one company to sell a job as a driver, but there are just one company or just two companies, no more than this. And then on the other side of the market, the monopoly is the same at the small business, the restaurants, and of course. And when we observe what's happened with the average hours and with the income from the workers who get a job at this part of the labor market, it's easier to understand how they manage the system and how they kept the condition. And when they have an opportunity, they really take the earnings, the main part of this, the extraordinary profits, the companies will take. And this group, this self-employed workers, in my opinion, there is no doubt, is a space to put in balance the labor market just on the bottom, mainly on the bottom of the labor market. Because if you have no more anything more to do, you try to work in the most part of situations, the conditions, as a self-employed worker. If you are a very specialized guy on IT, you chose your company, you chose your job, but not the question, not the point about the driver or the biker. It's not the case. But in both cases, the company will use their monopoly power, no doubt.
I have one as well. I have a question to Professor Manzano. You mentioned I am. Professor.
Good afternoon. Thank you for this time. In a point of view of you both, we can talk about companies that are intermediate workers, or we are talking about conglomerate kind of entrepreneurs that are concentrating just kind of money from another countries, and we are not more talking about one company, more two companies, or what kind of employer we are talking about nowadays. Because we have a lot of theories about economics from labor law, but I think we are in a university that we have to define more better for simple people, not for just the academic people. And we need to transfer this vision, to put another idea, but not another idea that we are just talking about theories, but put an idea with responsibilities. So I think I have to understand if you both have to categorize, have to define these entrepreneurs, these employers in short words, in a short sentence. How can you define, please? I need a kind of light.
Yeah, I want the same. I have the same question. It's not easy, yeah. Yeah, I think this is the difficult, yeah, because it's a new word that are emerging, and how I will try with my suggestion here, my hypothesis. The platform, in my view, in the end of the day, they are just this buffer in institutional building too difficult us to understand the relations between owners and worker, employers and employees, between who have responsibility about the economic developments, the economic earnings or losses. The platform, they emerge to mix it, our view about these traditional relations. Then it is difficult also, and how we can work, how we can do to clarify this for the public. It's a huge huge, como é que é, desafio, challenge, yeah, that sincerely I don't know how we can advance in that, yeah, but yeah, of course, this is a important aspect, important challenge, yeah, fundamental.
Okay, we talk and you ask us. Okay, I'm thinking about. I research about HR, human resource management. I will say that some companies who has a real human resource management look for people to hire with high skilled and high qualified jobs, and the companies prefer these guys because it's essential to their business. That's why they had good labor contracts with benefits, with vacations, with insurance, health insurance. And then when you think about platform companies, they really work labor as a commodity with a low quality hiring labor contract. This is. I guess it's and so. And I will look to Marcelo. They are looking to change the high skilled and qualified worker in a commodity, in the labor as a commodity every day, all the time. This is a trend. And that's why when we are observing what's happening with HR management, we have less people to study, because this is a point to study with a small group of workers. I'm worried about that, because we have organized institutional funds looking for pensions, looking for aposentadoria under a traditional labor hiring contracts. Not about that. And who will pay for a quarter of the occupied people working at a labor market when these guys couldn't more get a job? What will happen if these guys for the next 15 years? I'm thinking about that, and because we are living this. If we are just a researcher, my God, it's a very good moment to do my special survey, my special research. But we are living. It's more than I'm worried, really worried, because I'm at the end of I guess in my 5 years I will get I will retire. But what will happen with my relatives? I guess I think I hadn't yet an answer for you, but
Hi, professors. My question is, if you talk with doctors, CNPG doctors, they don't want to be hired as employees. If you talk with Uber drivers, they don't want to be employees. If you talk with housekeepers, they don't want to be employees, domestic employees. The argument is, I win more money, I save more money if I am self-employed. So, and I'm wondering why we students, labor students, are defending something the opposite of the workers wants, because they don't want to be employees. They prefer the juridic persons, and they pay taxes. So my question is, what's your opinion about this? Why they prefer the self-employed, workers and not employees? And what we labor students, labor lawyers can do to defend our point of view? Thank you.
Da advertência para o professor Freitas. Anotem aí, pessoal, é agora. Quem for aluno aí já vai dar uma dura nele agora. Joga pela janela, Freitas. Tudo indo.
Then we have another one.
Just an advice, don't be a labor lawyer. Forget about it. I don't advise you to be one. About the numbers we're saying, we were saying that they operate with losses. They do operate with losses. Uber only became profitable in 2023. So the company came up in 2009, and they only became profitable and minimum profitable on 2023. So it's the first year that they become profitable. And even before that, the company reached $102 billion stock market. Even being not profitable they gain money with the price of the stocks. So that's the point. And the second point is a lot of people say that the real core business of the platforms, transport platforms, are not transportation business. They're getting information. Of course, the magazine, The Economist, says that information is the new oil, and some other professor says information is the new uranium because it's so dangerous. It's not oil; it's the uranium. So what are they getting are not profits with the transportation business. What are they getting are information. They know the time we leave home. They know the time when we get home. They know the paths we do. They know where we go. They know what we buy. They know everything about us. So this is the main core business, most people say. A lot of people say, not most people, but a lot of people say. And maybe we were worried about the wrong thing. It's not the point. But the point is, what is the real core business of those companies? The real core business is the transportation business, or maybe getting information. And with this information, they get to point what we buy, where we go, and especially for the commerce. And the other thing is information for autonomous cars. We have Waymo in San Francisco, Waymo, with 400 cars already. And we have also Waymo and another company in Phoenix with more than 500 cars, completely autonomous, no drivers, no labor problems, zero. No self-employee, no employee, nothing. And all these cars, they need information about the traffic. They need information about the holes in the streets. And all this information is easier to get if you have a car fleet doing this for you, researching this. And many people say that, and maybe, just maybe, we're looking a wrong way. We're worried about the labor costs, and they don't mind the labor costs because they will get some other business some other point. What happened in China, of course, China has Didi, and Didi in Brazil is called 99. What happened in China, this Uber could not compete with Didi, so they become partners. So even in Brazil, if we think about that, we don't even have two companies because they are all partners outside. And this is a point that I always think, even like writing books or maybe discussing here, for how many months or years or for how many time all the things we're discussing here will be interesting because maybe it becomes history in a short period of time. So this is just getting, it's like a hook of what you said about operating in losses. This is maybe because they don't mind. They are looking, even Amazon took 6 years to become profitable, 6 years, 6 full years. Yeah, that's it. Thank you so much.
Being or not an employee or an independent contractor, it's not a matter of option. It's a matter of fact. Where you are or not. It doesn't matter if you want to be. It doesn't matter if you recognize yourself as being or not. So one of the things that is challenging, one of the things that is challenging for us is the regulation of this relationship.
Yeah. So I was telling that being or not an employee or an independent contractor is not a matter of option. It's a matter of fact. So under the legal standpoint, the important is to be or not to be fulfilling the requirements of classification as an employee or not. But the most important thing is that your question is very interesting. Some of the guys that are researching and oral interviewing workers of platform, they don't recognize themselves as employees. Not only they don't want to be, they don't identify themselves like this. So beyond the problem, the legal problem of classification, we have the identity problem that it's very important to, under the point of view of class and group pertença, which is in the Latin word, I think is better. So, okay. You're.
And then I thought something close to what Freitas told, because I guess the most important thing is to code if you are able to have an option, if you are able to have to choose. I guess a doctor, IT professional, and a teacher who could have an options as an employee or as a self-work employer, and even a driver at Uber or a biker. What we are researching is that a proportion of them really prefer to be a self-employed worker as a driver. Okay, I do my own working hour every day, no problem. But in this case, this is an option, and and he are able to choose. But the bigger part of them, there is no choice, because there is just one option at that moment. Because I have no money, and I have a job there, but just for a month. Just until I complete my college, just I complete my household reform or kind of, but just until I get the next wage or salaried job as an employee, and then this is the new but there are another side. Okay, it's a good thing that to have this part of the labor market as a possibility when this could be an option. When there is no option, I'm worried about that in some sense, because this I think it's a good side of this entire question is we have more job opportunities from the platforms. This is a fact. 26 million guys would be self-work employed workers. And this is better than no job, by definition. By definition, but we need to deal with this. The entire play is it's in question by now, I think.
Yeah, I agree with the two professors about the issue about your question. Nothing else to say about that. In reference about the losses of the platform companies, I think Karl Marx saw this problem in the middle of the 19th century, the 18th, yeah. No, the 19th century. When he wrote about the fictitious capital, that is the profits that the investors could made selling speculatives about the valuation from some assets. This is a promise, is not necessarily a real way to realize in the present, to realize profits, but it's a promise, yeah. And the platform companies, they do this very well. Your examples show that, yeah. The case of the Amazon, the case of the Uber, etc. Their value increase a lot without profits. Yeah, that's possible. Karl Marx wrote about that. This is the center of the capitalist way of organize our society. It's difficult to understand because it's look like a big contradiction. How a company could have 10 years of losses and their value in the financial market is increasing a lot. Yeah, it's possible. And and to sustain this strategy, they need to show to the market that they don't carry on the liabilities of the labor relations. That's why they press the laborers, they push the laborers to the bottom, yeah? It's not because they, of course, they want to, but it's not the first aim, the first objective. It's not because they want to extract plus value. It's because they need to show to the investors that these assets promise a huge future with a lot of valuation. And the problem is not now, it's the future. Now they need to have less liabilities, less risk, and design this model of business. I think it's that the game that platform digital play. Yeah, it's that. Sorry about my English.
Thank you, professors. Well, using my prerogatives as chair, I will give my 2 cents about this. Well, Osmar, I think part of workers want to be self-employed because at the end of the day, they will look at their paycheck and they will pay less taxes. So everyone wants to pay less contributions to Social Security, to IRS here in Brazil. So I think it's, even if they are formal. Two, as Professor Wilson showed us, the average of workers in platform economy, they are younger than in traditional economy. And these workers, they are or they never had a work card before, so be an employee, a formal employee is not, they don't see this as a possibility, or the experience that they had in the past, it was terrible. Because let's be honest, to be an informal employee in Brazil, at least, is not the paradise for the working class. We have many problems related to moral harassment, bad working conditions, and so on. So it's not the paradise. And are you aiming to be an informal employee? This is the best you can offer me to face the conditions I am having right now. It's not a good answer, let's be honest. And third, about the information, I agree that the most valuable thing that Uber can have is information, because this is how they make their services they are offering better, more accurate. This is how they make us, every client that they have, to be a regular customer. So this is another thing that they are using this information to improve their core business. This is an important thing that I see, at least. But I think we are reaching the time here. Thank you very much to be here. We have a quick break right now before returning. So
Thank you all for this great exposition. We're going to have a quick break of 15 minutes. We have coffee and cake. Please enjoy.
Tá. Primeiro a cerimonial que vai começar. Onde eu sento? Aqui. Pessoal, vamos voltar? Vamos iniciar o próximo painel? Espera eles.
Olá, pessoal. Antes de começarmos o painel, gostaria de dar um recado. Quem ainda não fez o cadastramento, por favor, procurar a Letícia para que possa consignar os nomes, por gentileza. A Letícia está sentada ali. Também aos alunos da pós-graduação que não assinaram a lista, por favor, façam para ter o certificado. Now we will resume our schedule with our last session of the day, with the exposition of regulatory developments in the United States, case of California. To preside the discussions, we would like to invite the Master of Labor and Social Security Law by Universidade de São Paulo, Specialist in Labor Law by Universidade Federal de Goiás, Professor and Researcher of Universidade de São Paulo, the Labor Judge of the Regional Labor Court of Campinas, Your Excellency, Mrs. Ana Paula Silva Campos Musklin.
Thank you. Hi, everyone. My name is Ana Paula Musculin. I have been a labor judge for 21 years, and I wanted to tell you how deeply honored I feel to be here beside these incredible professors that I have much admiration for. In my professional journey, I have witnessed many types of conflicts, including those involving child labor, workplace accidents, moral and sexual harassment, discrimination, and many other kinds of vulnerabilities. But for me, it was here in the halls of this university during my master degree that I began to see the world through new eyes. That's why I want to express my gratitude to the professors of this institution through these distinguished female professors who are here, women who dedicate themselves to studying, researching, and teaching because, like me, they believe in the better world. And so it is with great pleasure that I introduce our distinguished guest speaker, Professor Catherine Fisk. Professor Fisk teaches employment law, labor law, civil procedure, and understanding the U.S. legal profession at Berkeley University. She is a faculty director of the Berkeley Center of Law and Work and the Berkeley Center for Law and Technology. She received an AB summa cum laude from Princeton University and a JD from the University of California, Berkeley, where she was elected to order the cause. She is a renowned legal scholar known for her expertise in labor and employment law. With a wealth of experience in academia, she has made significant contributions to the field through her research, writings, and teachings. Professor Fisk is author of several books and has published over 100 articles and essays in leading publications. In one of them, published recently, which I had the pleasure of reading, she says the contract need not be the enemy of the effort to establish minimum labor standards. We are honored to have Professor Fisk join us today as she shares her expertise and perspectives on this pertinent issue, the constitutional challenges to extending minimum standards to gig workers, analysis of Proposition 22. Please, let's warmly welcome Professor Catherine Fisk.
Thank you very much, Judge, for that generous introduction. And thank you very much, Adriana, for inviting me to participate in your seminar. I deeply regret that I cannot be there in Sao Paulo with you. Just to remind us where we all are in this legal issue, let me begin by clarifying the enormous distinction in U.S. law at the moment between the rights of workers who are designated employees and the rights of workers who are designated as independent contractors. In California, and of course in the federal government, employees enjoy a wide array of legal protections, most that come from statutes, but some that come from case law, or what we call common law in the US. Employees enjoy the right to be paid the minimum wage, the right to be paid 1.5 times the regular rate of pay for hours worked in the day in excess of 8 in California. They enjoy rights to be free of discrimination on the basis of race, religion, gender, national origin, veteran status, marital status, sexual orientation, gender identity, etc. And a wide variety of other protections. Not as generous in the US, especially when it comes to social insurance, things like health insurance and retirement insurance. Not as generous as in some places in the world, but still a wide array of protections. Those legal protections typically are funded either by employers or through a combined system of payroll taxes that typically are paid in part by the employer and in part by the employee. And that, of course, creates the financial incentive for employers to classify or misclassify, meaning to wrongly classify, their workforce as independent contractors in order to have workers who can be paid less than the minimum wage and who have no protections against arbitrary firing, harassment, discrimination, and so forth. 100 years ago, there really wasn't much of a distinction in the law between workers who were employees and workers who were treated as independent contractors because the legal distinction didn't matter. But the more laws protected employees, the more employers thought of ways to classify their workforce as contractors in order to lower their labor costs and the risk of liability in the event of harassment, discrimination, and so forth. And there's been a kind of an epidemic of efforts to designate workers as contractors over the last 20 years. And of course, one of the most well-known of these is the strategy of app-based employers, of which Uber and Lyft, DoorDash, et cetera, are the most well-known. But the phenomenon of companies identifying themselves as simply technology platforms that enable workers, providers of a service like transportation, and consumers, that is, somebody who's seeking a ride to the airport or delivery of food or groceries, they say that, look, we are just the app, we're just the platform, we are not the employer, and that in fact, the workers are either sort of totally self-employed as operating a small business, or if they're working for anybody, they're working for the passenger or the person who requests delivery. This has been the business model of a number of companies. It's dramatically transformed delivery and transportation and has lowered labor standards in a workforce that can be where the work is quite hazardous, the risk of traffic accidents, and it has essentially shifted the cost of providing transportation or delivery from the companies to the workers themselves. The companies no longer have to maintain a fleet of vehicles and insurance to cover the risk of liability. They no longer have any risk of having to pay workers for downtime between when rides are requested or delivery is requested. They just pay for the time when the driver actually has a passenger or a delivery item in their vehicle. To combat the low wages and hazards of working in the industry, California has pursued a number of strategies, and that's what I want to explain to you. And then I will explain the current status of the litigation over these strategies to improve standards, and then the counter strategies to protect the app-based low-wage model from state regulation. And then at the end, I'll talk a little bit about other approaches that are being tried in California and in some other states and at the federal level to address labor standards in the industries that are most prone to misclassification. So first, worker advocates began litigating in the first and second decades of the 20th century to combat misclassification under existing law. The California Supreme Court decided in 2018 in a case called Dynamex that truck drivers, are employees of the trucking companies, sometimes called logistics companies, that they contract with to provide trucking services. Dynamex galvanized worker advocates to pursue legislation to expand the ruling in Dynamex, which at the time applied only to minimum wage and overtime laws, and was based, of course, on the particular facts of that trucking industry and that particular company. They tried to expand the Dynamax ruling to all workers in the state of California who were at risk of misclassification. They did so by getting the California legislature to enact a bill that is known as Assembly Bill 5, or AB 5. The reason it's still known as AB 5 rather than as the provision of the California Labor Code that was enacted is because in order to address the problem of misclassification on a wide-ranging way, it was necessary to amend many provisions of the California Labor Code to provide protections to ensure workers receive compensation if they're injured on the job, that's workers' compensation, to ensure they receive unemployment benefits if they are laid off, to ensure they're protected against discrimination, to ensure they receive the minimum wage and overtime and all the other protections, the 3 days of paid sick leave that workers are entitled to, paid family leave, and so forth. So what AB 5 did was essentially codify the ruling in Dynamax. And what that does is it adopts the so-called ABC test for determining who is an employee. The ABC test, as you might imagine, has 3 parts. But the most important thing to understand about it before we talk about the 3 parts is that it adopts a presumption that all workers in California are employees, unless the employer can prove that it meets all 3 of the elements of the ABC test, and therefore its workforce or some part of it are contractors. The presumption is the most important part of AB 5 because it puts the burden of proof on the employer. And in case of doubt, and the facts really matter in these cases, and proving facts, as you know, as lawyers, is expensive and time-consuming. And so it makes it clear that workers are employees in case of doubt. So what are the 3 elements of the ABC test? Well, they are, first, that the worker is free of the control of the hiring entity, both in fact and on paper. Second, that the worker is only a contractor if they operate their own independent business, providing the same service to the public as they provide to the hiring entity. And third, that the service that the worker provides is not the core service of the hiring entity's business. So take an example. Consider air conditioning repair. If I hire somebody to come to my home to repair my heater or my air conditioner, that person is not my employee because even if I control when and how they do their work, I am not in the air conditioning repair business. And therefore, one of the elements of the ABC test is not met. But of course, all of the elements of the ABC test are not met because air conditioner repair people provide that service to the public generally. And I don't really control how an HVAC repair person operates because I call them up. I say, my air conditioning isn't working. I don't know what's the matter. And they say, well, we'll come on Tuesday at 10 o'clock 3 weeks from now. And they come when they come, they do their work. I say, thank you. I write a check. And so I don't exercise control. I'm not in the HVAC repair business. And they're in that business providing that service to other people. But for an Uber driver or a Lyft driver, Uber is in the business of providing transportation services. They may say, no, we're just a technology company. But I would say that most people find that if you want to get a ride somewhere, you go on the app and request an Uber. It's a transportation company. It's not in the business of providing technology to the public. But however you come out on that element, because Uber exercises control over the drivers by requiring them to adhere to certain requirements, and because the workers aren't really in the business of operating a taxi service, but even if they were, because Uber exercises control, that's the end of it. Why does this matter, this three-part test matter? Because it establishes that most workers, except those who are truly in the market position to set their own rates and to protect themselves against hazards or the risk of downturn in the economy for their service through diversification of having lots of stable clients, or because they are highly educated, like lawyers and doctors, and are able to charge a fee for their service that will cover them during a time when they're not working. AB 5 protects primarily low-wage and less skilled workers. When the legislature drafted AB 5, it tried to draw a line between those workers who require the protections of minimum wage and overtime and safety and health protections and so forth by carving out a number of occupations from its protections. So as I suggested, lawyers are excluded, doctors are excluded, dentists are excluded, accountants are excluded, many people in the arts are excluded, like graphic designers, hairstylists are excluded because they typically have sufficient client loyalty that they can protect themselves, or if they're abruptly terminated by the salon where they work, you know, if you have a hair cutter that you really like, you'll follow your stylist from one salon to another because you have a relationship with them. You know, there were probably some carve-outs that were the product of particular lobbying efforts in particular businesses, because that's the way that legislation is made. Excuse me. But that was the theory behind AB 5. Uber and Lyft and some of the transportation companies, trucking companies, delivery companies lobbied hard to be excluded, but their lobbying effort was unsuccessful because, as the chief proponent of the legislation said, these are industries with high hazard rates. It's actually fairly dangerous to drive for a living, both the risk of car accidents, and especially if you're providing taxi service, there is a risk of passengers assaulting you, or just a risk of working long hours for low pay. It's an industry where there are a large number of immigrants laboring who need the protections of law. And so it was decided by the legislature to include Uber and Lyft rather than to carve them out in the way that law, medicine, dentistry, and the sale of real estate was carved out. So that's AB 5. Uber and Lyft and DoorDash and some of the platform transportation and delivery companies decided that since they were unable to get what they wanted in the legislature, they would appeal to the voters directly. California has had for about 120 years a provision in the Constitution, the state constitution, that allows the people to vote directly at an election on a statute, so that if the legislature refuses to enact a statute or does enact a statute, the people can organize to put on the next ballot a measure that would adopt legislation that the legislature refuses to adopt, or that the governor refuses to sign, or to repeal some legislation. California uses this device a fair amount. It used to be that it was sort of a way for the people to organize themselves to enact legislation. But companies have discovered, especially because the California legislature now has a supermajority of relatively progressive Democrats who are sympathetic to labor unions and workers on labor issues. Companies have discovered they're less successful in the legislature than they are by spending a great deal of money to put a ballot measure on the ballot and get the voters to enact a piece of legislation. And that is exactly what Uber and Lyft did. This measure is known as Proposition 22 because it's a ballot proposition, or sometimes it's called Prop 22 for short. What Proposition 22 does, and it passed, was it carves out app-based transportation and delivery companies from AB 5. And so it gave Uber and Lyft, DoorDash, and so forth, the carve out from AB 5 that they had sought in the legislature and could not get. So both Assembly Bill 5, AB 5, and Proposition 22 are now in litigation in the courts. So let me first explain the litigation over Prop 22, and then I will explain the litigation over AB 5. A business group went into federal court. Remember, in the US, we have two court systems. Each state has its court system where matters of state law typically are litigated. And in California, as in many states, the final word on state law is the state Supreme Court. But there is also a federal court system where the final word on questions of federal law is decided by the United States Supreme Court. So business went into federal court to challenge, sorry, I've been confusing here. Business went into federal court to challenge AB 5 because they don't like having their workforce declared to be employees. Heard what I said a few minutes ago. I'm going to start first with the challenge to AB 5, and then I'll explain the challenge to Prop 22. So in a case in the Federal Court of Appeals covering the western part of the United States, which is known as the Ninth Circuit, the case is known as Olson versus the state of California, and it was a constitutional challenge to AB 5. The business groups argued that AB 5 unconstitutionally discriminates against businesses like Uber, Lyft, trucking companies, by carving out other occupations, doctors, lawyers, cosmetologists, from the protections of AB 5, but leaving transportation and delivery services covered by AB 5. Their argument is unprecedented in the last 90 years in the United States. For 90 years, since the mid-1930s, federal constitutional law has been clear that legislatures can, when regulating the economy, draw lines. That the fact that they choose to regulate one occupation and not another, or one business and not another, does not discriminate in violation of the federal constitutional prohibition against discrimination that deprives somebody of the equal protection of the laws. Under the US Constitution, since the mid-19th century, at the close of the American Civil War in 1865, the Constitution was amended to provide that the government may not deprive any person of the equal protection of the law. It was intended to protect formerly enslaved people from the risk that at the conclusion of our Civil War, which was about enslaving of Black people, that legislatures would perpetuate discrimination by depriving Black people of their rights. For about 50 years after the enactment of this Equal Protection Clause, a very conservative Supreme Court largely read it out of existence. But starting in the 1930s, the Supreme Court recognized that the equal protection of the laws is meant to protect people from invidious discrimination on the basis of race, or religion, gender, national origin, etc. It wasn't intended to prohibit legislatures from deciding to regulate trucking companies one way and dental offices a different way. But a conservative panel of the Ninth Circuit in the challenge to AB 5 ruled that the California legislature's decisions about which companies to regulate and which ones to exclude was arbitrary, and moreover, the court held that the statements of the principal sponsor of the legislation in California condemning Uber and Lyft's business practices was evidence of legislative animosity. And thus, it was like the decisions of some legislatures, for example, to deprive Black people of the right to vote or to attend public schools. That is an unprecedented ruling because, if you look at the way the legislative process happens, there's all sorts of special treatment for this company as opposed to that company, or this industry as opposed to that industry. And of course, anytime a legislature enacts a law regulating a company or a business practice, typically legislatures stand up on the floor of the legislature and say, this business is shocking, or this sector of the economy has showed shocking disregard for the environment, or for the consumers, or for workers, or for whoever it is they're upset about. And so identifying particularly dangerous or harmful business practices or occupations is not animus. It's simply the way legislatures draw lines between the need to provide this degree of safety protection in this industry, but to decide that, well, no, this industry doesn't pose a hazard to consumers or to the rivers and ocean or to the workers or whoever. So the decision in the AB5 litigation in the Olson case was sufficiently shocking to judges on the Ninth Circuit that a majority of the judges on that court voted to rehear the case. The Ninth Circuit has about 27 active judges on it at the moment. The panel of 3 judges that rendered the Olson decision reflected in the view of the majority of the active judges, a view about the Constitution that they thought was inconsistent with the court's law, with the Supreme Court's law, and so they voted to rehear the case en banc. The rehearing was recently argued a couple of weeks ago before a panel of 11 judges, which is the way that en banc arguments happen in the Ninth Circuit. And observers of the argument believe from the questions that the Ninth Circuit is likely to overturn the panel's decision and to uphold the constitutionality of AB5. And therefore, the lines that AB5 draws, including trucking companies, but excluding hair salons or lawyers, will stand. But we will have to wait for that decision to be rendered. And of course, even if the decision is rendered upholding the constitutionality of AB5, it is expected that the businesses may go to the United States Supreme Court, which has the final word on matters of federal law. Businesses generally are fairly successful in the current Supreme Court because of the 9 justices on the US Supreme Court. 6 tend to be fairly reliable votes for business interests, and only 3 tend fairly reliably to vote for worker protections. And the current United States Supreme Court has indicated a willingness to overturn settled constitutional law in a wide variety of areas, especially when that will deregulate businesses to allow them to discriminate on the basis of sexual orientation or on the basis, in favor of some religions and against other religions, or to invalidate environmental regulations or labor protections. But to accept the business argument against AB5 would really be a radical change in American constitutional law. And if I had to guess, I would guess that the US Supreme Court isn't going to do it, but we'll see. So now let me turn to the status of the legal challenges to Proposition 22. Remember, Proposition 22 is the one that carved out Uber and Lyft and app-based transportation and delivery companies from the protections of AB5, thus designating their workforce as independent contractors with almost no protections of California law. A group of worker advocates challenged the constitutionality of Proposition 22 in California State Court because they believe that their best opportunity for challenging Prop 22 will be under the California state constitution, where the final word about the constitutionality of of Prop 22 will be with the California Supreme Court, which is somewhat more sympathetic to worker protection, as illustrated by the California Supreme Court's 2018 decision in Dynamex, which was more worker protective, although not quite as worker protective as AB5 is. So that case is called Castellanos. The trial court in that case ruled that Proposition 22 is unconstitutional under the California Constitution. It focused on two separate provisions of the California Constitution. The first one, the most important one, and I think the one that's most likely to be successful, is a provision of the California Constitution that confers on the California legislature the power and the responsibility to provide a complete and adequate system of workers' compensation. Workers' compensation law was created in the second decade of the 20th century, that is, about 110 years ago. It provides a system of compensation for workers who are injured or who become ill in the scope of their employment. It funds those benefits through kind of a combination of insurance that employers are required to maintain and a payroll tax system that provides kind of backstop benefits. Workers' comp is enormously complicated, but in concept, it's pretty simple. Any worker who is injured in the scope of their employment, regardless of whose fault it was, whether it was the worker's fault for failing to be quite so careful walking down the stairs or handling a saw, or the employer's fault for failing to provide a railing or to repair the loose carpet on the stairs, or a third party's fault, I don't know, a customer who accidentally or intentionally trips a worker when they're walking down the stairs. Regardless of whose fault it is, the worker is entitled to compensation and also to medical care to help them recover from their injury. This is important in California because not every worker has health insurance, and many who do, the health insurance isn't adequate. And also for workers who become unable to work because of an injury, it's really important to get prompt medical care that somebody is going to pay for, and also to get some payment to cover their lost wages while they are recuperating. And if they never fully recuperate, which is not unusual in workers who provide physical labor, they get permanent wage replacement, at least partial wage replacement. And that also can be enormously important because we don't have a complete national system that compensates everybody who becomes unable to work. And it often can take years to establish eligibility for those benefits, even when people are entitled to them. So businesses challenged workers' compensation on a variety of legal theories in the early 20th century, and sometimes had success in the courts in getting courts to invalidate workers' compensation. Or they would go into the legislature to try to get the legislature to carve out businesses or to reduce benefits or otherwise to reduce their costs and to shift more of the risk of accident and injury onto the workforce. And so the California Constitution was amended to give the legislature, not the courts, the power to create a complete and adequate system of workers' compensation. But it also imposed on the legislature the responsibility to do so. In other words, the legislature can't carve out this business or that business if it would render the workers' comp system incomplete or inadequate. All right. There was a second legal theory that was used to challenge Proposition 22, and it has to do with how the ballot initiative process works, these propositions. I'm not going to go into it because it's super technical and it's probably not of interest to you for your own practice or interest in the law of labor and employment. The trial court in California found Proposition 22 unconstitutional because it undermined the complete and adequate system of workers' comp by carving app-based drivers out of the system, which is important because, as I've said, the legislature believes that this is a hazardous occupation where it's especially important to have adequate protections. The California Intermediate Court of Appeal overturned the trial court and upheld the constitutionality of Proposition 22, finding that the state constitution does not prohibit ballot measures that carve out certain hazardous occupations from workers' comp. And the case is now in the California Supreme Court, where most of the litigation focus has been on the constitutional workers' comp provision. It's hard to know what the California Supreme Court is going to decide for a number of reasons. First of all, they're presented with a different issue than the issue that was presented to them in 2018 in Dynamex. And secondly, the composition of the California Supreme Court has changed a little bit. There are a few new justices on the court. Some of the others who joined the unanimous opinion in Dynamex are no longer on the court. And so we just don't have enough of a voting record to be sure of what the California Supreme Court will do. The final thing I'll say about that is that the way that arguments work in the California Supreme Court is the court will study a case for sometimes months or often a couple of years and have draft opinions written and circulated among the 7 justices on the California Supreme Court before they hear oral argument in the case. And then once they hear argument, they then have 90 days to issue their opinion. That's by command of the California legislature. So they tend to have made up their mind about the case before they hear oral argument. And so we will have a fairly good idea once the argument happens of where the court is going on that. All right, so that's the status of the litigation. The final thing I will discuss with you is other approaches to address app-based work in California and to some extent nationwide. So first, let me focus on the role of federal law. Under the United States legal structure, federal law is the supreme law of the land. That's in our US Constitution. And so whenever there is a conflict between federal law and state law, federal law prevails. But there has not generally been a view that there is a conflict when states choose to provide greater protections for workers or consumers, or sometimes businesses, than is provided by federal law. And particularly this is true in the law of the workplace and with respect to minimum labor standards. Federal minimum labor standards legislation is generally slightly less protective of workers than is state minimum standards legislation in California. For example, the minimum wage in California is currently about $16 an hour. And workers are entitled to premium pay for overtime work after working 8 hours in a day. At the federal level, the minimum wage is currently $7.25. And workers are entitled to premium pay for hours worked only once they exceed 40 hours in a week. And so California minimum wage law is more protective. Similarly, California, especially under AB 5, deems many workers to be employees who might be deemed independent contractors under federal statutes. Nevertheless, the current Secretary of Labor of the United States is working on expanding statutory protection and regulations for workers. I don't think there's going to be success in making those laws more protective than California law, simply because Congress will either intervene, especially if the majority of either our lower house, our House of Representatives, becomes more solidly Republican. It's currently a 1-vote Republican majority. Or if the Senate, our upper house of Congress, which is currently a slight majority of Democrats, very slight, with the marginal vote being pretty darn conservative, that probably will become more Republican after our November election. And so it's unlikely that there's going to be more progressive worker legislation because it's all getting blocked, which is why the minimum wage remains $7.25 an hour in the US, which is below the federal poverty level for full-time work for a parent supporting a single child. So there's a limit to what can happen at the federal level. However, as relates to California and some other states, there have been efforts to try to extend collective bargaining rights to workers, regardless of whether they are deemed to be employees or independent contractors. There's kind of two strategies that have been used to try to support unionization efforts in these low-wage industries. One is to try to expand the number of workers who are deemed to be employees under the National Labor Relations Act, which governs unionization and bargaining rights for employees in the private sector. The limit to that strategy for app-based drivers is that under federal law, independent contractors are carved out of the National Labor Relations Act. And there is some bad case law from the worker protection standpoint defining who is an independent contractor and who is an employee. The current National Labor Relations Board is working on seeing if it can reevaluate some of that old law to get to a broader scope for who is an employee and to narrow the independent contractor exclusion by focusing more on whether the hiring entity exercises control and whether the workers are in fact really independent and able to protect themselves through individual negotiation. But there's a limit to how far they can go. So there has been some activity at the state level in California and in other states. Currently, it's ongoing in Massachusetts to try to establish collective bargaining rights for any worker who is an independent contractor and excluded from the National Labor Relations Act. Those legislative efforts have proven to be very controversial, even among labor advocates, because one segment of the workers' rights community and the labor advocate community believes that by conceding that Uber and Lyft drivers in particular are independent contractors for purposes of enacting a law giving them state collective bargaining rights, it will essentially concede something that shouldn't be conceded as a matter of federal or state law. That it's essentially a political compromise that's not worth making. Another group believes that it's better, at least in the short term, to concede that app-based drivers and other low-wage platform workers are independent contractors for purposes of collective bargaining only, and to get state legislation enacted that would give them the right to unionize and bargain collectively. And so there's a lot of sort of political strategizing about what makes the most sense that focuses a lot on, could we cabin this to just collective bargaining rights at the state level, or would it undermine the efforts to support and defend AB 5, for example, or to attack Prop 22? The third strategy that I'll mention briefly, because the judge in her very gracious introduction mentioned it, is to try to change the duties that are owed by an entity that contracts for labor. And so I, as was said, have co-authored an article that argues, as a matter of contract law, both sides in a contract owe each other duties that are not something you can contract out of. And that the sort of fundamental duty of fair treatment that each side owes the other means that a hiring entity can't, for example, pay so poorly that workers are living below the subsistence level, or can't structure its scheduling rules so that what drivers experience as working time, for example, driving around or sitting in their car waiting to be summoned for their next ride, or driving from wherever they are to pick up a passenger or a package, that is working time as workers experience it. It's certainly working time if these workers are covered by either state or federal wage and hour law, because they are being, as the expression in the law is, they are being engaged to wait. That is, they are there waiting for a ride. They are performing the valuable service for their employer of being available. You know, they're not at home having dinner and a couple of glasses of wine that would make them unavailable to get in the car and drive. They're sitting in their car in a downtown area waiting for the time at night when people are wrapping up their dinner parties, you know, their dinner at a restaurant, or waiting at 2 or 3 o'clock in the morning when the bars close to drive people home, or waiting downtown to drive people home from work, or whatever it is. That is working time as workers experience it, and it's simply a violation of the principles of fair contract for companies to try to declare that as non-compensable time. And so I think if the legislative strategies fail, then we may see courts in some states taking a look at their contract law and trying to think about what are the obligations that each of us owes to another in a contract, and under what circumstances are really substandard labor conditions a violation of contract obligations, regardless of what legislation or ballot measures may say. And so with that, I'll close and thank you for your kind attention and for inviting me to talk to you today.
Thank you, Professor Catherine, for sharing your knowledge with us. And now we are honored to have Professor Adriana Calvo. She is an employment and labor attorney and professor of employment law at Fundação Getúlio Vargas, Rio de Janeiro, and at Mackenzie Law Schools. She's also a researcher at University São Paulo Law School, a member of GETRAB and GEMDIT, and she holds a PhD and master's degree in labor and employment law from the PUC São Paulo. Professor Adriana, the floor is yours.
Hi, everybody. I'm so glad, Catherine, to be here with you. I remember when I first met you, I was in California, so I visited Professor Catherine Fisk in her office at the university, and she was very kind to me because she gave me the opportunity for a talk for almost 1 hour. And on this opportunity, I had the pleasure to invite her for this seminar. And I've been learning a lot with Professor Catherine Fisk. Just for you to know, she's one of the head professors in employment and labor law in US. She's very well recognized. And the idea now, Professor Catherine Fisk, is just to make an interchange of ideas of what's happening in US that you've just kindly explained to us and what's happening in Brazil. And we're gonna see that we are very close, even though in territory, we are very kilometers away. But what is happening in US influences a lot what is happening in Brazil. And we have the same challenges. More or less, we have the same questions. And we learn a lot when we have this type of seminars because we exchange experience and maybe we can have an idea about the future when we talk about gig economy. Well, my presentation will focus on the discussion in what is happening in Brazil regarding regulating app. Can you help me here? It's not going to the next slide. I don't know. The idea is to give an overview, Professor Catherine Fisk, just an overview, a very summary one of what are the initiatives regarding gig economy in Brazil. First of all, one of the questions we had in our country is, should we regulate gig economy or should we not? Like my supervisor here, Antonio Freitas, he has a book in Brazil. Everybody knows his book about work on demand. And my supervisor here, he begins studying this issue as I'm a very good student, so I learned from my professor. In his book, he says, the first question we have to think is, should we regulate or not? Should state unions, judiciary, and other branches regulate this issue, or should we give it just to the free economy, free freedom of contractors? Well, we suppose in Brazil, we chose the issue of saying, let's regulate. And nowadays, we have 3 branches of Brazilian government trying to regulate. We have the judicial one, legislator, and executive one. Everybody in Brazil want to be the first to regulate gig economy in Brazil. So my presentation is to show Catherine Fisk what are the initiatives in Brazil and what's going on right now in Brazil. Well, let's first start by Brazilian judiciary branch, okay? So the same as in California, Dynamax was the first case by the judiciary in California that started in US a new precedent about gig economy. In Brazil, just for you to know, Professor Catherine Fisk, in 2019, we had 496 cases involving platform companies, app-based transport companies, most of them, labor claims in our labor Supreme Court, okay? From this 496 cases, we had 342 were discussing an employment relationship. So for you to understand, these workers, they would file labor claims saying that they were misclassified, as in US. They were saying they were employees and not independent contractor. But in Brazil, we have a labor code which states in Article 3 what are the requirements to be an employment relationship. Different from US, because US, you have to apply those crazy tests, right? You have a lot of tests like Professor Catherine Fisk explained to us that in California, they apply the ABC test. But in Brazil, no, we have Article 3, which states what are the 5 requirements to be an employee. So, Professor Catherine Fisk, those workers, they file labor claims seeking should be recognized as an employee. They say they have these 5 requirements foreseen by our labor law. And then what happened? Well, what happened is we had a lot of different judges who had different understandings about if they are employees or not. So there was a lot of confusion in Brazil, Professor Catherine Fisk, because we had different decisions, some saying yes, they are employees, some saying no, they are independent contractor. So these labor claims came to our labor superior court, because in Brazil it's a federal court. We don't have state courts like in US. Our legislation is just federal, okay? So I think it's easier from this point of view. But from the point of view of labor courts, we have a lot of labor courts, a lot of labor judges. Our judiciary is really big in Brazil. And then what happened? What happened is on 10th of June, 2022, the labor ministers of the Labor Supreme Court set a meeting to discuss that they should uniform the precedents. They should decide. I can't have different judges thinking differently about this issue. We need to uniform our precedents about this. And then there was a lot of difficulty between the ministers to get to a conclusion. And one of our ministers, Cláudio Brandão, he said maybe we should suspend the judgment right now, and we should ask for a special session with all the 27 labor ministers to do a wide debate on this issue and to really have a final decision about what is the status of these workers. Well, what happened? We thought in Brazil, we labor lawyers thought that finally TST, our Labor Supreme Court, would say and would conclude what is the status of those workers. But then what happened? Our federal Supreme Court wanted to talk about this also. They said, no, you Labor Supreme Court, you cannot tell what is the status of those workers. We ministers of the federal Supreme Court will have the last word. And then one of our famous ministers in Brazil, Minister Alexandre de Moraes, just for you to know, Catherine Fisk, he's now in a fight with Elon Musk in Brazil, just for you to know what kind of strong opinion minister we have in Brazil. And Minister Alexandre de Moraes, on May 19th, 2023, he accepted a constitutional complaint saying that a decision of the labor court, which recognized an employment relationship, was wrong. So in a way, he was against the decision of the Brazilian labor judge. He said no, in a monocratic decision, means just his vote, he ruled that the lawsuit should be decided by the civil courts, not the labor court. And he said that the platform workers, they are self-employed. They are independent contractors. He said, you know what? They are owner of their own vehicle. They are entrepreneurs. So they should be treated as a common civil contract, and they should be judged by the civil courts. And then we, labor attorneys, we got again very anxious about that, because we said, what's going on? What is going to be the next step in this situation? And then next step, after he did that, going to the next slide. after this bombastic decision, what happened is our federal Supreme Court decided that this issue about the Uber drivers and app-based drivers is such an important decision in Brazil right now that should be ruled as a general repercussion issue. And now we have a theme, 1291, to decide if gig workers can be classified as employee or not. Well, we are waiting because if you see, it's April 3rd, so it's very recent. So we are waiting to see what the Federal Supreme Court will decide about it. And meanwhile, I suppose the labor ministers of TST gave up their idea of trying to do what we call Tribunal Pleno, to decide this issue, because the Federal Supreme Court took the first step and said, you know what, we are the ones who are gonna decide if they are employees or not. But, next step, but meanwhile, when we are waiting for this judiciary discussion, because we're just talking about the Brazilian judiciary branch. While we were waiting about this, what happened in Brazil is we had an initiative by the executive branch. The executive branch, our recent elected president, Luiz Inácio Lula da Silva, our actual president, when he was elected, he declared his commitment to regulate the issue of the gig workers. He said he was committed to provide decent work conditions for this type of employees. After the election, on Labor Day, you know, a very special day on Labor Day, he approved the decree 1513, and he created a work group. So this work group was with a tripartite group with members of the business companies, members of the workers, and members of the government. And the idea of this group was to debate and propose a bill regarding this issue. So this group had government representatives, workers, and employers. And the idea was to really go through a debate, you know, a tripartite debate, which was a great idea, right, Professor Freitas? That's the best way. ILO says that we have to do solutions by tripartite negotiation, social dialogue. So I was very positive that we would have a good result about this initiative. But when we were expecting, I was expecting a wonderful bill. I was expecting an academic bill, perfect, you know, with a lot of good ideas, something really, you know, high-level bill. But then we got a bill like AB5, okay, Professor Catherine Fisk. It's an AB5. And in this bill, President Lula, unfortunately, because we were expecting the opposite, he said they got a consensus with the for-hill transport of passengers. So this bill is restricted to Uber 99, is not for all Apple-based workers. And during the ceremony of presenting this bill, Lula said, gig workers do not wanna be employees. Catherine Fisk, our president, who was a former union representative, a leader in Brazil, who really fights for labor rights, labor unions. Gus, he was like, you know, everybody were a big fan of him. He was the type of guy who would stop trucks on the streets and defend the labor rights. Now he is the president who says they don't wanna be employees. And this bill, Professor Catherine Fisk, is like a copy of Proposition 22. but it's really bad, worse than Proposition 22, because we have less rights than in Proposition 22. And our president says gig workers will be treated in Brazil as independent contractors with minimum rights, as minimum salary, social security, limit of hours of 12 hours. The bill says 12 hours. When I read that, I said, unbelievable. 12 hours. Our constitution says that every worker can work not more than 8 hours. And they say they cannot be working more than 12 hours. And this is something now that we in Brazil are very worried about, because discussing gig work is not only discussing gig work, it's discussing the future of work. So why we are here? We are not here just because of gig work. We are discussing the new forms of work. We are discussing the future of the labor law, the future of our sons, our grandsons, and what is going to be the future of work. I don't know. From all I've been seeing, I've been a little bit pessimist about the future, because gig work is not doing well in most of the countries. In US, as Professor Catherine Fisk gently explained to us, and in Brazil now with this scenario. And then what I want to just do a final remark about this discussion is, as Professor Freitas told us today, we never had a question about discussing if a person is an employee or independent contractor in Brazil. This was something that you usually decide on cases basis. Oh, on this case, this person is an employee. On that case, this person is an independent contractor. We had in Brazil, our history of case laws was always depends on the case. Now, if we have a bill saying that a category of employees, category of workers cannot be employee, it's like we're saying on this case, even though you have the 5 requirements foreseen by Article 3 of our labor code, you can't be recognized as an employee. And I think this is very dangerous, because we're saying that our law has to be put outside. If we put outside our law for gig workers, what is going to be the next workers that we're going to do that? Of course, if you tell me our Article 3 is not good, has to be reviewed, has to be modernized, has to be able to discuss new types of relations, I agree with you. Maybe we should do that. But we should do that by legislating, changing our labor code, updating the requirements to be an employee, but for all employees, not only gig works. I really don't understand why a supermarket has to have a lot of employees registered by law, suffering the inspection of the labor authorities, and why those app companies are not obliged to have any employee. And I want to tell you, like, I've never seen an employee for Uber. I went to the ILO seminar last year. I went to Switzerland, Geneva, and there the Labor Supreme Court said the employees, the app-based workers, were supposed to be employees. And I tried to figure out, where are those employees? None of them were registered, because Uber insisted on saying, no, we're not recognized employees. And what did they do in Geneva? They outsourced. They hired another company, and this company has to run the risk and to hire as an employee. So when I asked an Uber in Geneva, there was a message: do you accept having your services by this company? I said, what is this company? I don't even know what is this company. And then you have to say yes or no, and then comes an independent contractor outsourced by a third company. And in Brazil, if this happens in Brazil, we're going to have a higher risk, because our labor Supreme Court has said that pejotismo hired by a company is valid. Imagine if we come to this point. Well, my time is over. I just wanted to do an exchange of ideas with Professor Catherine Fisk. I thank you very much for your presence. Your lecture was really for Ana Paula here. She's a big fan of you. She read all your articles. She has a book about gig economy in Brazil, a brilliant book, and she knows all your articles. A lot of people who are here at the audience know you and know your articles. So thank you very much for your presence. You were really brilliant for us. Thank you. Have a good day. Agora você fecha.
Professor Adriana, thanks for sharing your knowledge with us. And thank you again, Professor Catherine Fisk. Now, I would like to thank all our audience here and at YouTube for staying with us until now. And I declare concluded this distinguished panel. Thank you.
Thank you.
Thank you all for being here today. We're approaching the end of our agenda, and we would like to thank Universidade de São Paulo and Tawil Sheker Meyer Brown and the professors and coordinators of this seminar, Adriana Calvo, Professor Freitas, and Elizabeth Tippett. Thank you all for joining us. And tomorrow we have the second day of our seminar at 8 a.m. You are all invited to join us. Please, Professor Freitas would like to. Okay, then tomorrow. Thank you, everyone.